Probate administration is handling an estate of someone who has passed away through the court system. Probate is the administrative process. It's not a trial, but it's the administrative process where if I die, someone has to be empowered to actually do the stuff that needs doing in my estate. So someone is going to have to sign on the sales paperwork for my house. Someone is going to have to access my bank account. Someone's going to have to pay bills. If there are no documents in place, we are going to use Minnesota's default rules to go through the court system and decide who gets what, here's who's in charge, here's the first priority, etc. You don't get a say in that. We almost always want to make sure we're overriding those rules. We can only do that during life, and the way we do that is we do a will. So probate necessitates a will necessitates probate. We are taking that court document, submitting it to a judge or a county registrar and saying, instead of doing the default rules, do this instead. The first thing we want to do with probate administration is we want to collect information about the beneficiaries of an estate, so who's getting the money. We want to collect information about whoever's supposed to be in charge. That's usually the person who's contacting us is the person who found a will, and they're listed as the first executor or personal representative. So the person who's contacted us is going to probably have some questions about what's next. And during their initial consultation, we're going to outline a little bit about what the next steps are. One thing is getting a hold of that will document. There's a number of different types of probates. There's an informal version of probate when things are very, very straightforward. Nobody's in any disagreement about anything. The assets are very simple. All the beneficiaries are adults. We know who they are. We know where they live. If it's easy enough, we can do this informal probate. That involves the attorney collecting the documents that are needed. We need an actual original will with an actual original signature on it with a notary stamp. It has to be properly executed with witnesses and everything. And assuming we have that, we're going to send that off to the county registrar. And oftentimes over the mail, we're going to be able to get that executor appointed and then get to work. So probate administration starts with getting that person appointed. If anything is funny about the estate at all, and by funny I mean ambiguous, people are in disagreement, the assets are not clear, we're not really sure who these people are they were talking about, then we're probably looking at a formal probate. And a formal probate is a very similar process, except it's going to be in person. So it's almost universally going to involve at least one court hearing. Whenever we do probate, part of the process is everybody who's involved has to have notice about their rights. So anybody who's a beneficiary of an estate, if we're going through probate, has to get a proactive notice served to them over the mail. It says, here's your rights, here's the date of the hearing, if there is one. If you want to challenge it, here's your rights. People rarely challenge it, but we do have to show them that they can, because it's a right, they have a property right and they need to protect that. We're also going to take an ad out in the paper and we're going to say, hey, this person has passed away. Hey, creditors out there, you've got 4 months to come get your money. It's a very public process, and that's why it works. We're announcing to the world this person has passed away. We're announcing to the world this person had a will, and we're giving everybody a right to contact that executor, that personal representative, and claim what's coming to them, or to say, you know, I disagree with what's going on. It's a public process to protect the rights of everybody by making it a public thing. Probate has a reputation of being incredibly expensive, and every state is a little bit different, and in fact every county is a little bit different. There are states in the US where probate is a $50,000 thing, and Minnesota is really not one of those states. Minnesota is very middle of the road. We typically tell clients, be ready for a $10,000 probate, but hopefully it's closer to $5,000. It's a range, and it's impossible to say what's going to happen until we're actually filing it, because that's when the issues start popping up. So we usually give that range. It can be more. Probate can be $20,000 and $30,000. That's less likely in Minnesota than some states. As far as time consuming is concerned, yes, the whole process just takes time because it's a process. It's meant to be a process. People get time to object to things. We have had probates recently where they're very straightforward. We just need to sell the family home. That's all we need to do is sell the family home. That's the only thing that went to court, is getting this thing sold. We need the executor to sign on the dotted line. That's it. And it's all going to one adult child. There's nobody to even disagree with what's going on. But we're subject and at the mercy of the court calendar. So it's not uncommon to have to make house payments on that house, pay property taxes for 8 or 9 months before you have the ability to sell it. So it is a process that's intentional. It gives everybody the opportunity to object to it, but part of it is there's going to be a pretty good waiting period there for most probates. The way we avoid probate is we want to make sure that the assets are under some sort of private agreement. Everyone has checking accounts, everybody has maybe an IRA, and oftentimes you can use a private agreement, a contract with the bank or the financial advisor or the company that's the custodian of that IRA money, that qualified 401k or retirement money. And you can actually fill out a private agreement with them that says, hey, if I'm gone, it goes to my spouse or it goes to my adult kids or whatever it might be. That's a private agreement. Private agreements don't need a judge. We sign private agreements every day. We sign contracts, we sign leases, we sign credit card agreements, and you don't need a judge to make those things work, and you don't need a judge to make that beneficiary designation work. There's some limitations there. You have to be a little bit careful because you don't want to name minors for that. It'll work, but it's going to go to court and it's going to go through a custodial arrangement or a conservatorship. And you can't really do any backups. I can't say to my spouse and then to my adult kids, and if something happens to one of my adult kids, it doesn't go to their spouse or it goes to their kids. You don't get any control there, but it's good for very simple stuff. Another type of private agreement, though, is a trust, a revocable trust specifically in this case. And what we're going to do there is we're going to create a private family entity, it's called a trust, and we're going to make sure our stuff is pouring into this thing. So we do a real estate deed for the home or the family cabin. It's revocable. You can sell this house or sell the family cabin anytime you want to, but we want the stuff directed to our private family entity. Anything that ends up in this thing, I can have my bank account name the trust as getting the money. I could name my wife as getting it, but I could also name the Philip and Mary Trust, and in it goes. And then whatever happens at my death, it's outlined in here. It's a private agreement. It's a trust agreement. It doesn't need a judge. So if we can get assets under private agreements and they're valid and they're well thought out and they're not ambiguous, that'll avoid the probate process. So you're usually going to see beneficiary designations and revocable trust planning to avoid that process. Do-it-yourself probates are going to be subject to the same limitations of any do-it-yourself work. I'm very hesitant for someone to represent themselves during their own divorce. I'm very hesitant for someone to represent themselves during any sort of criminal proceeding, like a DUI. You're probably going to have a better outcome if you're working with folks who know what they're doing and have done this before. I speak with the county registrars pretty regularly, and they spend a lot of time walking folks who are struggling through this on their own without an attorney. It slows down the process, but also throughout the whole process, there are almost universally mistakes. A very small example of this is the need to keep names very, very consistent on everything. And what you'll see from that's a very low level thing that should be common sense to any attorney, but other folks who are doing this on their own just don't know about it. For example, if I have a real estate deed and that real estate deed lists the name Philip J. Roos, well, all my documents need to say Philip J. Roos. If they say Phil Roos or Philip Roos or Philip John Roos or whatever it is, now we have inconsistencies, and sometimes we have to go back and redo those things. So it's tiny things like that folks don't know, but there's also large things. Is there a bond required? How do you get a bond? If there are subtrusts or something, how do we qualify that? Are names clear and ambiguous? Do we have things filled out correctly? If it's not filled out correctly, even if it gets accepted, that doesn't mean it's right. If it gets rejected by the registrar, well, you can fix that. Preferably your attorney will help you with that so it doesn't get rejected to begin with. But it takes the whole process. It makes it longer. It makes it more ambiguous. It makes it error prone. And very importantly, that executor, that personal representative, is a fiduciary, which means any mistakes that happen, they are personally liable for that. That's their own responsibility. Do you want to subject your own assets, your own money, to your performance as a personal representative? Because if you make a mistake, you're on the hook. Or do you want help with that from someone who's done this any number of times, probably carries professional insurance, by the way? That's oftentimes one of the biggest benefits of hiring an attorney for a probate administration. Our firm has been administering probates consistently since we opened in 2013. I personally have worked with probates as a trust administrator. Sometimes there's a trust administration that also has to have a probate. Our attorneys in particular have been doing probates for years. We have one attorney who comes from California, which is a tremendous probate state, and the probates are very complex there. Minnesota is, by comparison, a fairly straightforward probate estate, and he has been able to get these done very efficiently, very informatively, quickly, and as minimum of an expense as you can do when it comes to a probate administration. When contacting us about a probate administration, you're generally going to have a short intro call with an attorney, and that attorney will walk you through the process, give you an idea of what you need to provide in order to move forward. They'll give you an idea of cost. It's very, very, very difficult to come up with a solid cost on a probate because we don't know what is coming around the corner. We'll file it thinking this is the case, and then all of a sudden there's a beneficiary who we weren't told about. And if something like that happens, or if there's assets we didn't realize, that can sometimes cause probate to be a larger process than we anticipated. But you're going to get a good faith idea based on what we're seeing of what that costs. In addition to getting an idea of that, you'll get an idea of how long this will take, what the next steps will be. If it sounds like something where you'd like to move forward, that attorney's going to have a questionnaire for you. It'll talk about you, it'll talk about the assets, it'll talk about the beneficiaries. It'll include a list of the things we need, whether they're death certificates, copies of original will documents, whatever it might be. It'll be very clearly laid out for you what is needed and what is next, and by which time we need that.